Well, just as you thought, it couldn't get any more exciting. Up pops the health and safety bloke. I'm actually involved in a number of very interesting and well publicized health and safety investigations and prosecutions at the moment. One being the Bow crane collapse that you may recall from last year, when a crane came down in East London, killing an elderly resident, injuring several others, and basically causing untold property damage. And also one that occurred at the Corniche on the Albert Embankment, where a pane of glass fell 26 floors onto a passing bus driver, resulting in his death. So there's a lot going on in the construction industry, and it's not, as you will see, terribly positive, because construction continues to have the highest rates of death and serious injury within any industry sector. And I thought I'd just pick out a few headlines. In sort of 2021, the number of deaths that occurred in the construction sector amounted to 28%, over a quarter of all fatalities that occurred through all sectors. So very high indeed. 81,000 workers are currently suffering work-related ill health. And of those, 57% have musculoskeletal disorders. But perhaps really importantly, this all equates to 2.1 million lost working days at a cost of 1.2 billion each year. Now, I know it's sort of easy to bash the construction industry, but in fairness, it has had an awful lot to contend with, tackling COVID, in addition to all the usual risks that arise on construction sites, which, as we all know, are extremely complex workplaces with lots of comings and goings. So it isn't that surprising that construction has a great big target pinned to its backside so far as the HSE is concerned. They are very much probably the most targeted industry sector. The HSE will continue to look at poor standards and unsafe practices in order to assist in reducing ill health, death, and injury that occurs on site. At the moment, particularly popular, working at height, the general organization of sites, welfare facilities, as well as things like dust and asbestos. So it's not a great position for construction companies or for individuals. Spot checks will continue to take place. An inspector may arrive on site for one particular purpose, then discover other poor working practices that cause him to then look very carefully at whether he should be taking enforcement action, either against a company or an individual, or indeed both. And the case that I always like to trot out is the case of Harlow District Council and G4S. And this should make everybody very concerned, because this involved a case where Harlow were investigating a Legionella outbreak, which included an employee of G4S. So they attended the G4S workplace and found no connection between the water systems and the onset of Legionella suffered by this employee. However, what they did find is some flaws in the safety management systems which they decided was so serious that they decided to prosecute. And G4S were fined the very rich sum of £1.8 million. So just goes to show, they came in, they were looking for a connection between the workplace and Legionella, but actually couldn't find it, but actually noticed all these other things, and they decided we're going to have to act. So they will act, and that could be by way of an improvement notice, a prohibition notice, or indeed prosecution. And I won't go into it in too much detail because of time, but so far as improvement and prohibition notices are concerned, if they are not challenged, they will be a permanent stain on a company's character. So they will be there for all to see and could well have reputational and commercial impacts. So if you were the recipient of an improvement or indeed a prohibition notice, look very carefully at the basis on which it has been issued. And if there are grounds for appeal, then I strongly recommend that those grounds are pursued. If successful, then obviously it won't form part of the company's permanent criminal record. Last year in the construction industry, over 2,000 notices were issued. So far as prohibition notices are concerned, 56% of all prohibition notices issued across all industry sectors were issued in the construction sector. And another piece of alarming news is that 96% of all prosecutions that were taken forward were successful. And the reason for this is because of the reversal of the burden of proof. So all the prosecution needs to establish is risk. And once the activity that is considered to breach health and safety law is established to have been a risk of injury, then it is for the duty holder to show that they did all things reasonably practicable to control that risk. And that is a very difficult burden to overcome. So far as individuals are concerned, the HSE's enforcement policy statement makes it very clear that the role of directors, managers, employees, and indeed individuals should be considered in criminal investigations. And in deciding whether to prosecute individuals, the HSE must be satisfied that the evidence provides a realistic prospect of conviction. Once that is established, it then becomes a matter of whether it is in the public interest to prosecute. Prosecution will always be warranted in cases where there's been personal acts or failings by an individual, and it would be proportionate to prosecute, bearing in mind the nature and extent of the breach and the risk that arose from it. Action should be focused on those who are responsible for the risk and are best placed to control it. Section 37 of the Health and Safety at Work Act is aimed specifically at directors and senior managers who consent to or turn a blind eye to poor practice, as a result of which the company commits an offence. Section 7 looks at individual workers who act in a way that puts another worker's health and safety at risk. And to top it all off, there is the prospect of gross negligence manslaughter. This is a crime that is committed when an individual in an official position commits an unlawful act which they should have been able to see would result in the death of another. And the elements to this, so far as the individual is concerned, is to determine whether that individual owed a duty of care. Was there a breach of that duty of care? Did it cause the death? Was there an obvious risk? And was the negligence so gross that it amounts to a criminal offence? So penalties, as you will see, because they are very well publicised, are giving rise to significant fines. But the bit I really want to focus on is custodial sentences, because there have been a marked increase in the number of custodial sentences that have been imposed in the last year. A few years ago, the number of custodial sentences was around about 12% of the whole. Last year, this rose from 12% to 22%. Almost a quarter of all sentences imposed are now custodial. Obviously, a company cannot be sent to prison, but individuals can. There is far more interest in individual culpability now than probably at any stage. People want someone to be held accountable. And in addition to that, the courts have power to disqualify any director from between 2 to 15 years, depending on the seriousness of the offence. So I can't emphasize more how important it is for senior individuals within any organization to make sure that health and safety practices, or good health and safety practice, is properly being taken forward. I just want to, Catherine follows me, and she's going to talk about agency workers and from an employment perspective. So I just want to, Catherine and I sort of had a conversation, and we agreed that I would have a look at this from the health and safety. It's a real concern to me that I'm seeing more and more investigations of organizations and indeed individuals as a result of the engagement of agency workers. And what we are tending to see is that because of various pressures around completing a project on time, additional workers are being sourced, but no one is actually doing proper due diligence around the capabilities and competence of these workers. And therefore, workers or agency workers are being assigned tasks that they may not necessarily be competent to take forward because the necessary checks haven't been carried out. So I really want to emphasize how important it is that if you are using agency workers, you satisfy yourself before they ever come on site that they are competent for the task you have in mind, that they go through a proper site induction, you check their licenses, you make sure they see any relevant risk assessments, that they are properly instructed and supervised, and that there should be some form of on-site assessment to make sure you satisfy yourself that they are actually able to do the work that you are asking them to do. There have been, as I say, a number of cases where this due diligence hasn't taken place, and very significant fines have been imposed on organisations, one fairly recently, which amounted to £275,000. So really something to take very seriously at the moment.